Hey guys, welcome to the show. Today we have kind of a different and a timely episode for you. We're going to talk about two criminal cases that are currently capturing the nation's attention. And these are the cases of the Lindsay Clancy trial and Luigi Mangione. And regarding the Clancy trial, right now it is going on. It is soon going to be in the hands of the jury. So we are going to primarily focus on that one. And here to help us understand what is going on inside that courtroom and what matters most to a jury is a special guest. He is an attorney with over 25 years of experience. He has worked on both sides of the criminal justice system. He has worked as a prosecutor and a criminal defense attorney, so he brings a unique perspective to all of this. In 2013, he was also appointed to lead a violent crimes unit as the chief prosecutor here in our hometown, working alongside local law enforcement as well as the U.S. Attorney's Office, ATF, and FBI. In addition to that, he is also frequently called upon by local news media outlets to give his analysis on high-profile cases, which he is going to do for us today. So stick around. We're going to get into all of the strategies, the evidence, the defense, when it comes to the Lindsay Clancy trial. And if we have time, we're also going to talk to him about Luigi Mangione, what's going on with him. He just pled guilty in a federal court, and we will hear from the trial lawyer himself. We are going to ask him, is it like we see in the movies and the books, or is it something completely different? Guys, please help me welcome Leland Hulbert, attorney, to the show. Hey, Leland.
Hello. How are you?
Good. How are you?
Good.
We're glad to have you here.
Happy to be here.
All right. So I'm assuming most people watching probably know about the Clancy trial, but do you want to, in case there is somebody out there, just give us a little synopsis of kind of what's going on?
So basically, and I haven't watched every second of the trial, but I've been following it, and it's about a mother who allegedly strangled her 3 young children while she was going through some sort of psychosis or postpartum depression. There's been a lot of conspiracy theories online about who really did this. Did the husband have something to do with it? I haven't seen a trial that has this much interest in a long time. I'm not sure it quite rivals OJ, but it seems like everyone has an opinion. It seems like, from what I can tell, just talking to people, women are following it more closely than men, because the issue of postpartum, I think, is something that women understand better. But you can't have a news, you can't watch the news these days without seeing this case. So I feel like it's captivating, and I feel like there's a lot of twists and turns as far as the timeline people are talking about, because the whole notion of it is everyone thought, well, she did it because she's trying to say she lacked criminal responsibility. So saying she lacked criminal responsibility, she'd have to somewhat admit she did it. So she pled not guilty, but her attorney is trying to argue that she was somewhat out of her mind when she did this, right, or lacked the ability to understand what she was doing. So I think as the trial has unfolded, a lot of people have developed an alternative perpetrator, being the husband, because for whatever reason, his demeanor or his, the timeline doesn't quite add up, and there's some facts that don't quite add up. So it's a very interesting case, and my understanding it's getting pretty close to being over, and the jury will likely have it here soon. So interested to see what happens.
Yes, me too. And I would totally agree with you. I think it is very interesting how it has really captivated everyone. And when I talk to people about it, I get such widely varying opinions on this. I have had some friends who are just like, she needs to go to prison. And I've had some friends who have gone down, I guess, kind of that conspiracy theory with the husband. And then, again, just as you said, I think there's a lot of interest in it because of probably women's mental health issues. And also, for the listener, I'm just going to do a quick synopsis of kind of what happened. But basically, Lindsay and Patrick Clancy were seemingly a pretty happy family, and they already had 2 children. They had the birth of their 3rd child in, I think it was May of 22. And in September of 2022, Lindsay begins having extremely bad mental health issues. And she sees multiple medical providers. She is put on a whole slew of psychiatric medications. She has been admitted to the hospital. She has been in and out of emergency rooms. There are frequent texts where she voices to family and friends that she is having a lot of trouble. And all of this ultimately results in, as Mr. Hulbert was saying, that we don't exactly know what her diagnosis was. There's been some speculation that she had bipolar with psychosis or postpartum psychosis, and this ends with her taking the lives of her 3 young children. So tragic. And also trying to take her own life in January of 2023. And she jumped out of a window, and she is now paralyzed from the waist down. So as Leland Hulbert was talking about, she has pled guilty to the murders of her 3 children. So Leland, being that there's a guilty plea here, what are we arguing about?
Well, I think she's actually, from my understanding, because there's some misconception, I think she's actually pled not guilty.
I'm sorry, I meant to say
No,
not
it's okay.
guilty.
Well, because I think there's a lot of people who said she's pleading guilty, but insane. Well, the insanity defense is not even technically in Massachusetts. It's it's called criminal responsibility. And we can get into that later about the legal standards and how they're a little different in Massachusetts. But basically, she's trying to say that, she hasn't testified and said, I did it. Mm-hmm. But they're asserting the defense that if she did it, then she lacked the substantial capacity to understand what she was doing. Right. So much so that she should be allowed to be in a mental institution and not a prison.
Right.
So, I've heard a lot of different conjecture about it, because most people say, well, if she didn't do it, and they've had 3 years to investigate it, and she has a good attorney, why aren't they just asserting a normal not guilty plea and moving forward? And I think that's a fair argument. But I think this was their strategy that they developed, and they thought this was her best chance to avoid prison. The fact that she had these episodes. Now, her attorney is doing a very good job of poking holes in the facts and the timelines and things like that, like he would do if they were going for a straight not guilty.
Okay.
So he's kind of doing both, which is what any good defense attorney would do, because the more doubt you sprinkle into the jury, it's hard to get 12 people to agree on, what the color of milk is.
Right.
Much less get 12 people to all agree a verdict. And, with a unanimous verdict, you can't have 5 people think one way and 7 people think another. You have to have everyone agree. And I could see in this case potentially holdouts where you could get a hung jury because not everyone can agree what happened, because I don't know. I think a lot of people are aligned on one side or the other, or one theory or another, but I'm not sure you're going to find, if you talk to 12 people in a row on the street, they all think the same thing. So
right. And explain that to me again, because I may have misunderstood that. I actually meant to say when I was explaining it that she was pleading not guilty basically by reason of insanity. So what exactly is she pleading?
She's pleading not guilty.
Okay.
And then she's asserting that she was under an extreme mental condition when this happened. Okay. She's not testifying and saying it happened, but it's an interesting position to take, because they can argue both ways without arguing. In other words, they can assert that she had these extreme mental issues, she was on all these medications, that she was out of her mind when this happened. But they can also say, well, what about the husband's behavior is very odd, or his timing is odd, or a lot of things he has done are called into question. So if they sprinkle in maybe he did it, without saying that, it's just creating doubt. So they're not pointing the finger at him. A lot of people are saying the investigation sort of glossed over him. It's hard to say. It was 3 years ago. Yeah. I know they pulled the CVS video. He went to CVS. They pulled the restaurant video. And so they obviously looked somewhat into his alibi or his story.
Yeah.
So I don't think he was ignored.
Yeah.
Anytime there's a murder in the house, I mean, the people in the house are obviously the most likely suspects.
Right.
But it does seem that there's some, perhaps best case for him, they're character flaws or poor decisions he made. It doesn't mean he's a murderer, and it doesn't mean he set all this up and orchestrated everything. I mean, I've heard everything from he drugged her to, he put her, he committed these acts, left, came back, tried to cover his trail, and it's possible. And there are some things that don't quite sit right with me about him, but he's not on trial.
Right. And I will say, just for the record, and again, I think just some of my medical background too, I'm looking at it from that standpoint, but I personally am not on the bandwagon with Patrick Clancy had anything to do with it. I actually think that he is, to your point, he may have some character flaws, but I personally don't think that he did this or had anything to do with it. And I will give you that, yes, are some odd things about the timeline and, yes, some of the data with the watch and all of that. But, all right, well, let's get back to what you were talking about earlier. So the burden is on the prosecution here, right?
Correct.
Okay, so explain.
In Massachusetts, the burden is on the prosecution to prove that she was criminally responsible. And I believe they've called a psychiatrist of their own that examined her. In Kentucky, it's more the burden is on the defendant to prove that they were insane or temporarily insane. But in Massachusetts, from what I can tell, I'm not licensed in Massachusetts, but just my reading of what I've found is that the burden is on the state. So the state has to affirmatively prove that she knew what she was doing or she was capable of understanding her actions. So much so because the insanity defense is sort of popularized by movies or sensationalism because when it is actually invoked and succeeds, they're extreme cases, but it's often asserted and fails. Or it meets the scrutiny when a doctor examines them. You always have competing experts, but you typically will have a doctor who says, well, they knew what they were doing, or one that says they had no idea what they were doing. So, and I think this case is going to come down a little bit to the science, but probably more to the facts and the timeline. I mean, juries are not typically highly educated in the ways of psychosis. Right. So they will listen to the doctors, but it's easier to follow facts. It's easier to follow pictures. It's easier to follow testimony. So when, briefly I watched parts of the father's testimony, Patrick, and, the people were commenting online that he's emotionless and he's somewhat robotic. I thought he's also kind of calculated in the way that he's a tech guy. And so there's talk about, he sent messages from her phone and her computer, and he would know how to manipulate all of that. But, I can't imagine the police ignored him. So to think that they just dove to her and, I've talked to other people who thought it was also odd that 2 days after this happened, the most traumatic thing that can ever happen to a father. I can't imagine anything worse than her children being strangled if, she did it. And then he announces 2 days later that, I forgive her. Right. But it's also asserting she did it, not me. So there's this trial has shown that there's really two ways to look at everything. And everyone has a comment or an opinion online. And it's just sort of taken on a world of its own about people presuming things.
Yes.
So it'll be a very good case study to see if the jurors ever talk, if anybody writes a book, if anybody gives an interview, because what was going through their head. Because usually they will tell you what they found was important.
Mm-hmm.
All of us are concerned about maybe red herrings or things that are inconsistent or trying to make a conspiracy theory work. But the jury hopefully comes out and tells people this is what we really focused on. And that's where you can learn. I mean, it's invaluable for any lawyer to hear what a juror thinks, because it doesn't matter what the lawyer thinks, and it doesn't matter how much law you know. If you can't communicate the law in an understandable way, and if you can't communicate the facts to a jury, you're at a big disadvantage. And I think, from what I can tell, she has a very good attorney who's telling a story that is going in enough different directions to poke holes in the prosecution's case.
Right.
So.
Yes, I would agree with that. And I have specific questions about the attorneys. How important, you brought up the jury, how important is jury selection in a case like this?
Jury selection is always very important, but for sometimes different reasons. It's not like getting the right 6 people or 7, 12 people. However, it's not choosing people. What I always tell people, you don't pick a jury, you pick who you don't want on the jury.
Okay.
So in other words, just a typical criminal circuit court case in Jefferson County. You'd have 50 people sitting there, and everybody does jury selection a little bit differently, even county to county in Kentucky.
Okay.
But you have 50 people sitting there, and you ask them questions. And the only way you know what people think is if they raise their hand. So an attorney's job is to ask questions they will answer. You don't ask them about some complicated law. You ask them about who has a bumper sticker, who has a dog, who has children, because you get a little bit of information on each of them.
Okay.
But they say the goal is to find out if anybody's really biased.
Okay.
So if there's someone you think is going to hurt you, you can strike them. But you can only strike so many people. The judge can strike people for cause, like if they have a surgery scheduled, or they know someone in the case, or they have a super strong opinion, something. But then the attorneys get their peremptory challenges. But it's really who's left is on the jury.
Okay.
So I always say you get 25 people who didn't raise their hand, and 12 of them are on the jury. And that's not exactly true. But you don't pick who's on, you just get to pick who's off. And so you never really know what you're getting with a jury. So I tend to think most of the time they follow the facts. Every once in a while, you'll have a case where one juror is holding out, and he's probably going to hold out no matter what happened. And that does happen. But generally speaking, I think they're somewhat in it together, especially these longer cases where they've seen each other every day. They're sitting there for 8 hours a day for a month or 2 months or whatever. And so I think agendas disappear the longer the case goes. But you never really know what you're getting. You're just trying to eliminate bias.
And when you say agenda, you mean people who are partial to feeling one way or another.
Right. I mean, everybody, if you have a, electrician on trial and you're an electrician, you may feel a certain way about electricians. Or if a mother's on trial and you're a mother, you might, so it's everybody brings their own experiences, and there's no way to eliminate all bias. It's impossible. So people hopefully meet in the middle on reason, what makes sense, follow the facts. But to say, I'm sure all jurors leave their personalities at home and their history at home is ridiculous. Of course they bring it with them, and they judge that way. So yeah, I think whoever has the more reasonable argument, who makes points that really hit home to the average juror, you're going to score more points that way.
How important is it that the jury likes the attorneys?
So in jury selection, that's your first chance to introduce yourself to the jury.
Okay.
And that's a good, everybody's like, well, we have to pick a jury. Well, no, it's really you're introducing yourself. This is a first impression. I think it's good to communicate to them on a more simple level. You don't try to talk like a lawyer, you try to talk like a person.
Right.
And I think humor can help. I think emotion can help. If you have a sad case, so you're trying to but you don't really argue your case, but you start to argue your case. So in other words, no one's testifying, there's no witnesses, but you can start getting in little nuggets about what you want the jury to see this case as. Okay. So that's very important. And I think that I always like that part of it because they don't really know what they're doing. Most people there have not sat on a jury before, and they don't know what the case is about. So they're hearing everything from you. They'll get a brief little tidbit from the judge, but they're learning from you. So if you are likable, they're more likely to listen to you, and it's about trust. It's like any relationship. So the more they trust you, the more they will listen, and the more they don't trust you, if you have people that yell and scream or turn the jury off for whatever reason, they're less likely to pay attention to you. So.
Right. Okay. Well, along the same lines as just follow up about the lawyers, I would agree with you, and I just have been researching this. Kevin Reddington is pretty much a top-notch attorney. Apparently, he is well-known in the Boston area, even though he's not known to the rest of the country. So that's Lindsay Clancy's defense attorney, who I think is doing a very good job. I have a question for you about some stuff that's gone on with the prosecution. And I don't know if you're aware of some of these specific things that happened, but I just wanted to get your take, and I have to explain a little bit. So the prosecution, have you heard about this part where they've introduced religion into the conversation?
I read something about the defense asking for a mistrial because religion was discussed. I don't know every detail about it, but I know that general part of it. Yeah.
So just to explain to the listener, basically there were two instances, and after the second one, that is when Kevin Reddington asked for a mistrial, and I do want to get your opinion on that as well. But the first instance, the prosecution has Patrick Clancy's mom, so Lindsay's ex-mother-in-law, because they're now divorced. But Patrick Clancy's mother is on the stand testifying for Lindsay. She is saying that she was a great mom. She was struggling terribly with mental health issues. The mother-in-law was a labor and delivery nurse. She was trying to get her help. Somewhere in there, it comes in that the family went to church together. I think it was Mass, either Christmas or Thanksgiving. And the assistant DA says something like, well, did you know that murder is a mortal sin in the Catholic Church? So that's strike number one. Of course, everybody gets in they're in a kerfuffle. Okay, so that's the first thing. The second thing that happened was we have a witness who is a forensic psychologist testifying for the prosecution. And this guy is trying to work out a reason that Lindsay Clancy would have murdered her own children, because so far there's no motive, because, she's, by all accounts, an all-star mom up until she started having like really bad mental health conditions or problems in September of 2022. So this witness is on the stand. He is a forensic psychologist, and he says that he thinks she murdered them and she knew what she was doing because she was very suicidal and she was going to take her own life, and she wanted herself and the kids to be together in heaven. And then he makes a comment that it's his understanding of Catholic religion that is not going to happen. And I guess I don't know that much about Catholic religion, but I guess that's because if you commit suicide, you don't go to heaven. I don't know. But anyway, once again, fists are slammed, pencils thrown down, and it's like, okay, we need to meet. And this is the second time something happens, and this is when Kevin Reddington asks for a mistrial later. So tell me your thoughts on the prosecution strategy. How risky was that? And what does a mistrial mean? Do you think Kevin Reddington was serious?
Yeah, so anytime the prosecution, typically the prosecution, makes an error that could prejudice the jury, you would ask for a mistrial. assuming your client wants to. And really, you're doing two things. You're laying the groundwork for an appeal.
Okay.
Because those key issues can be looked back upon when you appeal. And it's a lawyer's duty, really, to ask for a mistrial if there's a reason that there could be prejudice introduced by the prosecution. And in this case, I don't understand if they're trying to say she was not a good Catholic, or if I don't understand their point for bringing in religion other than to kind of make her sound worse, or say that her reasoning was flawed, or even just to introduce, from what I understand, this is if it's Massachusetts, it's probably a large Catholic population.
Okay.
Would be my guess.
Okay.
So I don't know if they're trying to say she's against God or against the Catholic faith, so what she did was wrong, but I don't know why it's necessary. I don't know why they would choose that route to score points. And I don't know if it was a misstep by their witnesses or if this was they knew this was coming.
Right.
So sometimes, you never know what a witness is going to say. So
yeah,
with experts, you should know.
Right.
But if their whole theory of the case is that, she wanted to be in heaven with them, theoretically that has religious overtones. So is it completely improper for them to mention it? Probably not. And is a jury going to rule one way or the other based on this introduction of religion? Probably not. So I think that's why the judge continued the trial. I mean, a mistrial, if it's granted, the trial stops.
Okay.
And starts, and the prosecution has to decide if they want to retry the case or not.
Okay.
Same thing with a hung jury. If there's a hung jury in this case, the prosecution would have to decide at some point if they want to retry the case.
Okay. So a couple questions about that. So if there was a mistrial or a hung jury, and explain to us what a hung jury is, but either way, what happens to Lindsay Clancy?
Well, it depends. Her attorney, in a general sense of a mistrial or a hung jury, the judge could address bond after, saying, well, prosecution, you screwed up, so I'm going to let this person out, or I'm going to lower their bond, or I'm going to put them on home incarceration, or I'm going to do something different. Okay. They can be granted relief. And the prosecution could decide, we were going to lose this trial anyway, we're not going to try this again. Or we're going to try this 50 times if we have to, So, but the legal effect of it is that the trial is over. Okay. But it does not mean that the charges can't be brought back or retried. So they don't disappear. Okay. It's just the trial was sort of voided.
And so when you said the strategy about an appeal on the defense's part, what does that mean exactly? So
a lot of times, especially in cases that aren't as winnable, a lot of defense attorneys, and especially, public defenders have to go to trial because their clients don't want to take anything. And they have to kind of throw everything against the wall and hope something sticks. And you're also lining up grounds for appeal. So anytime the prosecutor has a misstep or the judge has a misstep, you can object. Then you're sort of preserving the record because you're saying, I don't agree with that. And then if you ask for a mistrial, it's noted that you're objecting to that. So appealable issues are more ripe for appeal and more allowed to be appealed if there's an objection. If there's no objection, you're somewhat allowing it to happen. So unless it's some major egregious error, it's better to always object. And appealable issues, basically, if the law was not followed to such a extreme point that it prejudiced the defendant, or a clear law was broken, then a court of appeals a year or two later could, 6 months, a year, it takes forever, could render an opinion saying this case has to be retried, the conviction is set aside, we're undoing what you did because there was such a large mistake. And I've had that happen on a trial that I had as a prosecutor. There was an evidence mistake, and the Court of Appeals said, no, you got to do it again. So we had to go back and try it again. And, it happens. Judges have to follow the law. Prosecutors have to follow the law. Defense attorneys are a little more. They don't have. It's not that they don't have to follow the law. They have to follow decorum, but they're not the ones on the hook because the prosecution has the burden of proof.
Okay.
So the defense can sit on their hands and do nothing, or they can argue. Lawyers can't get out of line as defense attorneys. They can be reprimanded or sanctioned. But for a mistrial, you typically see it errors for the prosecution, and for an appealable issues, the prosecution's doesn't really have the same right to appeal if there's a not guilty verdict. They can appeal if there's a major legal mistake, but it's typically the defendant's appeal. And a lot of times defendants are sitting in jail and have free lawyers, public defenders, state lawyers looking at their appealable issues, and they've got nothing to lose because they're sitting there, they've been convicted. So a lot of cases get appealed, so the appeals court sees a lot of questionable, reasons for appeal. Because they're literally, at that point, they are throwing anything against the wall and hoping something sticks. But that's why there is an appeals process to sort of check and make sure the judge and did everything the right way and the trial proceeded under the law.
Okay. Well, tell us this. In a case like with Lindsay Clancy, so if she is found to be not guilty, where will she go after this?
It's a little different, and depending on the state, but my understanding, if she's found not guilty because she's can't appreciate because of criminal responsibility, right?
Okay.
Then she will go to a mental institution. And Kentucky actually just changed this law. I believe Logan's law just went into effect about a month ago because someone got out early, not necessarily with, I'm not sure if he had mental issues or not, because there were other things in the law as well. But this House bill passed and the governor signed it, is my understanding. And you have to get another layer of mental health assessment before you can be let out. And if you go to prison, in Kentucky, you can go to prison being guilty but mentally ill. It just means you get special programs, but you're still going to prison. And they're saying now if you get out, you still have to be monitored, or a doctor still has to say you're okay to be let back into society. So it's just about putting restrictions on people that have mental illness.
So, okay, two questions about that. So if she's, say, not guilty, but she's in a mental institution, for lack of a better word, who makes the decision as to when it is okay for her to come out?
I think it would be a finding by the institution. In other words, wherever she is housed. I don't know in Massachusetts it's if they have reporting every 60 days or 90 days, or if there's a date by which I can't tell what the Massachusetts law says. But typically that decision would be made by doctors. It wouldn't be necessarily back to the judge. It can be brought back before the judge, maybe for the ultimate decision. But when people get found guilty, it's out of the hands of a judge and it goes to the Department of Corrections. So then the Department of Corrections, like in Kentucky, has the ability to assess through probation and parole, through prisons, through other employees to assess a person and their likelihood to reoffend or their mental stability. But it's typically not a judge doing that examining.
Okay. And along those same lines, she is, I don't know if I said this in explaining the case, but she is paralyzed from the waist down. She is in a wheelchair. So if she is found guilty, and in addition to that, she's on a 1-to-1 suicide watch, which she's been on for 3 years, and she took the lives of her kids. But if she were to be found guilty, does she go to a special prison? Are there places like that for that?
Yes.
Type of thing?
I would. My assumption is yes, because that's what this is all about. And every state that I'm aware of has these type of facilities, whether it's a secure psychiatric facility, whether it's a part of the prison, whether it's usually an independent facility that's guarded.
Okay.
So that's where I assume she would go. How her disabilities and her lack of functioning would be monitored, I don't know. I'm assuming she would still be on suicide watch. I mean, I don't know the ins and outs of how her treatment would go and how her monitoring would go, but it's not like once the trial's over, she's cured.
Right.
I don't think anybody thinks that.
No.
So
Let's hope not.
she will need, regardless of the outcome, she's going to need probably intensive treatment. And, I think it's something the jury may likely take into account too, as far as the human element, the sympathy element.
Right.
I don't know. It'd be interesting to see how the jury does feel about her, because it's much easier to sentence someone you hate
Right.
than someone you feel sorry for.
Right.
And the defense has done a good job of planting seeds as to why she has a very sympathetic case.
Well, and I don't know if you saw this, and I think I sort of, in some of my questions, I think I was asking you about this, but yes, there's a moment where, Kevin Reddington, her defense attorney, chooses to leave her in the courtroom with the autopsy examiners testifying, and of course she's in there when there's the 911 call that Patrick makes, and I mean, she is sobbing at points. Is that a good decision for Kevin Reddington to leave her in the courtroom?
I think so, because especially when you juxtapose it to him, the dad not really reacting to anything. He was more kind of stone-faced. So I think, there's not as we discussed before, the jurors are people. They're humans. And when you see another person suffering or crying or, I think it's definitely a factor. Right. How big a factor, I don't know. I mean, a lot of people fake emotion, and a lot of people, but I don't think many people think she's faking.
Yeah.
I think I don't know how any juror doesn't think she has extreme mental issues.
Right.
The question is how extreme, and how did they affect that evening?
Right.
So.
True. Yeah. Yeah. Okay. Speaking of the medical mental part of this is my last question about the Clancy trial. But I think there is some civil litigation going on against the medical providers. Again, she saw numerous medical providers, numerous different diagnoses, numerous medications were thrown at this woman. And just regarding the civil cases, is that something, how does that work? Let's say that, let's say Patrick Clancy's family, because they're divorced now, wants to file a civil suit. And then Lindsay Clancy's, is it all under the same umbrella, or are they different?
So if they both wanted to file against the medical providers?
The medical providers, I'm sorry. Yes.
Yeah, they I don't think you would find them joined
at
the beginning because of obviously the rift between them.
Right.
But a judge could theoretically join the claims.
Okay.
Normally in a civil case, you're suing, as a plaintiff's lawyer, you're suing anybody and everybody with deep pockets, anybody that might be responsible. It's not just one doctor.
Right.
It's the doctor, it's the hospital, it's the drug manufacturer, it's the, they try to lump everybody in, and then the defense's job is to try to get themselves out of it, say, well, it wasn't our fault, it was their fault, or, so pointing the finger. But I've had cases before where you have a criminal case and then a civil case that's a companion case. In other words, they're the similar topics. Usually the civil case takes a back seat because defendants, people who have been charged, don't want to give a statement. They want to keep their right to remain silent. So they can't depose them. And the civil lawyers often wait to see what happens in the criminal case, because if a person is found guilty, like let's say someone shoots someone and then the family of the deceased person wants to sue the shooter. Well, they can do that for wrongful death or whatever reason, but if the person is found guilty of murder, they're much more likely to win their case. Okay. So the civil cases sometimes take a pause. Now this case is so different because of her medical condition and her defenses. My understanding is the civil cases have been filed because although I don't do much civil work, I know there are obvious statute of limitations. So you can't just sit on a civil case for 10 years and decide, I'm going to file now. A lot of cases have a year or 2 years. And if you don't file, you lose your right to file. And that's like, day you walk out of law school, that's anybody, they tell a plaintiff's lawyer, you miss the statute, you're in big trouble as a lawyer. So that may be what's going on here is they filed and they've done some preliminary work, and you have different attorneys who have different interests. They're about billing hours or losing money for their clients having exposure. It's all about, civil cases are typically about money. And criminal cases are about punishment and loss of freedom. So they're separate but co-aligned, and I would expect the civil case here to sort of take a back seat. Civil cases can take 5-10 years. Whereas criminal cases typically go a little bit faster, the right to a speedy trial and things like that. There's just more freedom and constitutional rights and implications with a criminal case than a civil case.
What about if she were found guilty, can she still do the civil case?
She could, because, what people remember, like OJ was found not guilty, but then he got tattooed in the civil case for many millions of dollars. Because it's a different standard. Because civil cases are a preponderance of the evidence. So like 51%. Or it's even a proportioned fault. Like who's more at fault for liability. So like let's say the hospital's 30% at fault and the drug manufacturer's 20%. That's how they assign fault. Whereas criminal, if you're found guilty, it's beyond a reasonable doubt. So if you want to put numbers on it, we sometimes tell a jury the preponderance is like 51%, whereas beyond a reasonable doubt is probably closer to 90, something like that. So different standards and different ways to approach each case.
Some of the medical providers' testimonies, the people who were treating her prior to the murders have frankly been just not great. So I was curious, how important is it what they're saying on the stand right now? Can that come back to haunt them?
That's an interesting question because they do not have a right to remain silent if they don't likely have any criminal exposure. So if they're just named as the nurse in a civil case and they didn't break the law, they just maybe made a mistake or did something that's outside of their area, that's not a crime. So the only time you find people that will not testify is if they have a right against self-incrimination and something they say could get them charged. Like I think people know about Dr. Fauci. He pleaded the fifth a million times recently because the fear is he could be charged with something. So he's doing that. And that's why people plead the fifth. So when you have a nurse testifying how she treated Lindsay or what she prescribed or whatever, that wouldn't really come into criminal exposure unless she has an independent lawyer who tells her you did something that's a crime, you can't testify. And of course that would look suspicious. So I think back to your question, everything that's in this trial will be deeply examined by the civil attorneys. And they will pick what they want to pick and go chase whatever depositions they want to chase. This is a good blueprint for them, but they're separate kind of cases.
Are these things usually settled out of court?
Well, most trials, most legal proceedings are settled. Some never make it to court. Many never make it to court. Some make it to court and settle. If the judicial system tried every legal matter, you'd need 7,000 jurors in every county, and it would just be ridiculous. You couldn't possibly try every case. So I always tell people when I'm talking to them, I said, when I do like my fee structure, I say, well, this is what it costs to represent you. If we go to trial, it'd be an additional fee. But I tell them 98% of cases settle, which is true. It doesn't mean that lawyers, you see trials on TV, and every legal show is about trial.
Right.
But I would say 97, 98% of cases settle, more out of, sheer numbers. You get a speeding ticket, you're probably not going to trial.
Right.
But the trials are what are interesting, and they would captivate audiences and sell movies and TV shows and things like that. So we focus on trials,
Right.
but I think the reality, I think 98% is probably accurate.
Right. All right. I think we do have time for 2 quick questions about Mangione. So for the listener, if you don't remember, you probably do, but Luigi Mangione is the young man that has admitted now in federal court to shooting Brian Thompson, who was the CEO or a CEO at United Healthcare. Mangione says he had an axe to grind with the health insurance system, back pain issues, something of that nature. I think we're seeing a theme here, Leland, about healthcare.
Right.
But anyway, okay, so Luigi Mangione has pled guilty to murdering Brian Thompson in a federal court, but he is not in New York State court. Tell us the...
So I looked into this because you had told me that this might come up, and so I did a little research, and my understanding is he has pled guilty to stalking in federal court and not murder.
Okay.
Because murder doesn't typically go in federal court unless you murder like a police officer or a politician or a string of murder. You know, there's federal laws are different than state laws.
Okay.
So it's an interesting strategic point of view by his counsel to plead him first to the stalking.
Okay.
And then trying to argue double jeopardy and say, well, now you can't try him for the murder, which double jeopardy is typically has to be the same elements.
Okay.
So you couldn't try him for murder and then try him for murder again in state court. But I haven't read the statutes for both, for Massachusetts and stalking and the federal, but I guarantee you there's different elements. So typically if there's different elements, obviously, then I would think the Massachusetts or the New York, the New York trial on state charges would likely go forward. But I don't know what his sentence is. I don't know if he's in prison for 30 years, maybe not, but I don't think he would be on just stalking.
Okay.
So he didn't plead to killing this person. He may have admitted to it. I don't know all the proceedings, but it sounds like his lawyers made the strategic choice of let's have him plead to the smaller offense and hope that precludes him from going to trial on the larger offense in state court. But I would doubt. I think that's their argument right now.
Okay, gotcha.
But I would doubt that passes muster.
Regarding this case, I think a lot of people know, and this is probably true for the Lindsay Clancy case too, there are public support for these people, like Luigi Mangione and Lindsay Clancy. And I know, like, for Brian Thompson's family, that's got to be really, really hard. But how hard is that for, you know, lawyers and jurors when there is a lot of public support?
So what you always tell the jury, and what the judge specifically tells the jury, is you have to follow the law, right? And so I always tell people if it's illegal to, you know, throw a Coke can in a trash can, then it's illegal to throw a Coke can in a trash can. If it's illegal to paint your door green and the defendant painted the door green, then he's guilty. In other words, even if you don't agree with the law, you have to follow the law. So that's where jury selection come into play. You've got to find people with the agenda. You know, let's say there's a Mangione supporter who will do anything he can to help him, and he will never find him guilty. You have to find that person. The prosecution has to find those people that are so biased that, and of course, they're probably not going to tell you. So that's where there's background research and things like that. In a case like that, my guess is the voir dire, the jury selection is much deeper. More questions, more, because like it's like a death penalty case. In a death penalty case, you ask a lot more questions because you have to get, if a person has moral or religious objections to the death penalty, it wouldn't be proper for a death penalty, you know, jury, that kind of thing. So I think it matters. I think it's important if he has supporters. You don't want them on the jury as a prosecutor, and you only need one of them if you're the defense attorney.
Well, what about jurors just generally? Okay, like let's say they find Mangione guilty. I mean, is there like, do you hear a lot about jurors getting harassed, and are there Are their names released afterwards? I mean, is it public knowledge?
They're not supposed to be. I think there's probably more fear about that these days with AI and everything can be hacked into. But typically the grand jury is super confidential. And then the jury itself is somewhat confidential. Only because you and I can walk and sit in the courtroom and see who the jury is. You never get to know who the grand jury is. I mean, there's some ways to figure out who's walking in the hall at a certain time or what, but as far as the actual proceeding, it's closed off. It's just recorded. You hear voices, but you don't know who's on it. Whereas a jury, we can all walk in. The news typically doesn't show their faces. The judge instructs the news not to do that, which for obvious reasons.
Right.
And then the jurors themselves can decide, do they want to go public? Do they want to write a book? Do they want to go on Dateline? Do they want to talk? Without exposing other jurors. Right. It's more of an individual decision. But they're protected, but it's not private because they're sitting in a public courtroom that theoretically anybody can walk in and watch the trial and see who the jury is. So it's the grand jury is probably, and that's where they decide when to charge. That's probably the most secretive, but the jury process is protected but not secret.
All right. Well, let's round out this discussion with a couple of questions about you. As I was talking about in the introduction, you've worked on the side of the prosecution and the defense. Where did you start out?
So I was a county prosecutor in Jefferson County, which is basically misdemeanor cases. It's actually all misdemeanor and felony cases kind of start there, and then the ones that you resolve as misdemeanors, typically your DUIs, your lower-level drug offenses, things like that. I did that kind of prosecution for about 7 years. Okay. And then for 7 or 8 years after that, I went to the Commonwealth Attorney's Office, which is state prosecution, and that you're prosecuting felonies. So more serious cases, more, district court is somewhat factory-like because there's so many cases. You can only give a few minutes to each case or even less as a prosecutor, except for some cases if you have a trial or something like that, or if it's, domestic violence cases get looked at a little more closely, and DUI cases have some more resources. But generally speaking, your docket is 1,000 speeding tickets a week, in a larger, or, triple that in a larger city or something. So you just can't give them as much time. But the Commonwealth Attorney's Office, cases have to be indicted and come up. We call it coming upstairs, going to circuit court. And so then you're doing discovery and evidence. That's where you exchange the evidence, your body cam, your witness statements, your videos, your things like that. You don't do that in district court on the felonies. They're all preliminary matters on felonies to decide if they should go to circuit court. And then once they're in circuit court, you have a different judge, you have a different prosecutor's office, and everything's just more serious because, you are risking potential prison time. Whereas district court is just jail time, a year or less.
So when you were working for the prosecution, what was your biggest misconception about defense attorneys?
So I can say it now because I am a defense attorney. I think that you don't really know until you're in their shoes. I think my clients now that I deal with do need help. I was worried as sort of a little moral dilemma, am I still going to be helping people? Because the prosecution, you theoretically wear the white hat and you help the victims, you have victim advocates, and you're helping protect the public. And I was worried about that shift. But what I realize now is I think I'm actually helping people more because people don't know the law. People are disadvantaged because police have so many more resources. And when an officer pulls you over, he can be trying to, one, protect the public if it's some sort of emergent thing, or getting people off the streets, or stopping a drunk driver. I mean, all of those are great, but they can also pressure people. And I see a lot of cases where they're overstepping, or people. I'm shocked how many people still let an officer search their car or talk in a case about it, because you don't have to, but nobody knows that.
I didn't know that.
And they feel the pressure of now. If they smell marijuana or they have a reason to search, then they can search your car. But generally speaking, if they pull you over for a speeding ticket or a taillight, they can only investigate that part. And if they see more, they can go further. But a lot of times they'll say, oh, by the way, can I look in your trunk? And people are like, oh, okay, because they don't know.
Right.
And I think with TikTok and it's amazing people do know a little more of these things than they used to because of social media. But so at the end of the day, I don't think prosecutors that have never been a defense attorney have a lot of sympathy for defendants. And at the end of the day, I think they trust the police a lot.
Yeah.
Now, I have a lot of friends that are police officers and detectives, and some of them are excellent. And they do great work, and they protect our city. And it's a very hard job now, especially with body cam and things like that.
Right.
But there are those that make mistakes. And, you know, the mistakes they make put people in jail that shouldn't be. And that a lot of that goes on more than you would think. People get overcharged. It's an interesting system because you have to have people that enforce the laws. I believe in that. And you have to have laws if you're going to make society work. I believe that too. But I do think when a general person gets pulled over or investigated, they're at a disadvantage until they have a lawyer. And a lawyer can kind of level the playing field. So I didn't really have that perspective as a prosecutor. I was like, these people are guilty. The cop's telling me he's guilty. He must be guilty. And a lot of times people are guilty of something.
Right.
But it may not be exactly what the police officer thought it was. So that's why I do believe that everybody's entitled to a competent defense, and that makes the system better. If either side could do whatever they wanted, it's not going to be a productive system. It's kind of like the checks and balances. Like people complain about Congress never getting anything done. Or, you know, if you're not going to pass any laws if you got one side controlling. If you have a debate or if you have a checks and balances, it's the same thing with prosecution and defense. And the judge. You know, the judge is there to make sure things are fair. So I like the system better than the political system. It makes more sense to me. So,
well, you just answered one of my questions, which was, well, actually, no. If there was one thing you could change about the legal system, what would it be? I would like it to be even more open to the public. I think a lot of judges are open to that. You know, Zoom is now a thing. You can log on to Zoom in some courts and see, but like federal court is closed. I've never understood that. That's where all the resources are. I mean, federal courts kind of pick and choose who they want to try, and they have a lot of resources with the FBI and funding, and they handle a small number of cases compared to state courts. But it's very important, you know, what they do, and because these laws are the laws of the United States, not just the laws of Kentucky or Massachusetts or New York, and those trials are all closed. All you see is sketches, and I've never understood that. I don't know why they're not open. Interesting.
So I think if we're having a legal system that protects us and that we all have to operate under these laws, let's have more intelligence and more transparency about what the laws are. Or, you know, because ignorance of the law is not an excuse. But it should be, especially the more complex the laws are. So I believe in opening up as much as possible, transparency. If people want to come watch court, as long as they're polite and don't disrupt, so be it. Let them in court, and everything should be more open. And I guess we're trending in that direction. I mean, there's 24-hour news channels that focus mostly, and you know, local news is mostly focused on crime or mostly focused on court cases. So it's either that or politics. And so you are seeing more. I mean, the Lindsay Clancy trial is a good example.
Yeah.
Everybody has an opinion on it. I think that's a good thing. If you get people talking about the laws, I think that's better for society.
Right. Oh, absolutely. Yes, which actually does lead me to another question. What do you think is one of the most pivotal cases that we've ever had in this country, or maybe that you've ever worked with, in terms of changing public opinion or...
Well, I guess I'll start personally because that's easier.
Okay, sure.
I was a prosecutor that we prosecuted a football coach. A lot of people had said that it was a forced practice, that people had to run until somebody quit the team. It was 105 degrees, you know, it was very hot. There are a lot of circumstances that, you know, we ended up losing. And I learned a lot from that case about how football is, I mean, I'm a huge sports fan, but how people do not want to find football coach guilty of anything.
Okay.
But the reason I mentioned that case is because it changed a lot of standards. Apparently, maybe even nationally, as far as water breaks and ice towels. And if hopefully it saves a few kids' lives or even professional athletes, you know, they just look at it differently. Because, you know, my father's generation would be like, well, we had salt pills. Like, we didn't even get water. Like, why are these kids are soft? Well, you don't want kids dying because they're not having water or having heat exhaustion or having strokes. So that case was important to me, and it wasn't a win, but it was just what I learned for it and hopefully affected some change. So for me, that was kind of a big one. Nationally, I mean, my wife and some other people follow these trials like Lindsay Clancy every second of it.
Yeah.
You know, they're very interested in it. I'm not quite, I think because I do this for a living, I'll read the headlines, I'll read some articles. This one is interesting enough that I paid some attention to it, but I don't really follow the national trials as much. But, you know, I'm sure I'm missing one or two, but it seems like OJ was the biggest because it was the first one on TV and everybody was glued to it and he was found not guilty. And, you know, they've made many docuseries about it, but I'm sure there's 50 since then that are also very compelling. But that one always comes to mind, probably because of my age. And I remember watching it and where the Bronco was and all that stuff. So that's the one a lot of people know about from years ago.
I remember that one too. I remember where I was sitting when the Bronco was going down the interstate. All right, I have a few just silly questions for you. What's your thoughts on when you're prepping for a trial? Are you a person that stays up all night, or do you insist that the team gets sleep?
Well, I think the number one word that you would use for a good lawyer for trial is preparation. So if you simply believe that luck favors the prepared, I mean, you have to. There's things that come up in trial that you didn't see coming. So the more prepared you are, the better you are to handle it. Now, my lawyers can also be procrastinators at some point. So I'm not sitting here telling you I prepare 6 months in advance. It's usually because you don't know. You'll have 20 cases that could go to trial and one that does. And that's the same for even prosecutors. Even the ones that try a million cases, most of their cases are not trials. So you can't prepare like that in advance for all of them. But once you knuckle down, usually you have to get evidence and experts and things together well beforehand. There's an exchange of evidence well beforehand. But as far as what you're going to say, writing out your opening, writing out your closing, that's usually the very close in time to the trial. I don't stay up all night. I learned in law school that pulling an all-nighter it doesn't help you think straight. No. Cramming doesn't really work. And you have to be, you're a presenter, right? Yeah. So if you're sleepy or if you're irritable or you're not presenting well to the jury. So presenting, if I had advice for a young lawyer, don't stay up till 4 a.m. studying for trial. Now, most lawyers are nervous enough, they'll go to bed at 11 and get up at 4 and start preparing early in the morning. I used to do that because I couldn't sleep that well, and you're more fresh in the morning. So, the trial itself is difficult because if you're on day 2, you're exhausted. Yeah. But you have to go home and prep for the next day. Right. And then, I never wrote my closings until towards the end of the trial because I didn't know your closing should be based on how the trial went, not on what your preconceived notions were. So, I'd prepare a PowerPoint or do that 2 nights before or the night before. And so it's most lawyers lose weight during trial. It's an exhausting process, but it's pretty neat, right? It is. You either love it or you don't. And, most lawyers probably would tell you they wish they went to trial a little more. There's a lot of reasons lawyers don't, like expense and time and, clients can't afford it. And, but there's nothing quite like being in trial, and it's exhilarating and exhausting, but it's really where the legal system is at its best.
I love that. Yes, it is fascinating to watch some of these cases. I mean, you couldn't write a book like this. Speaking of which, we'll end with this one. Do you have a favorite that comes to your mind? Movie or book about trial lawyers? I'm not going to sit here and say I'm the biggest book reader on. Again, it's kind of like the TV shows. I don't read many legal books because that's kind of what I do for a living. Gotcha. But when I was younger, and I really liked the book and the movie, A Time to Kill. And I think it was made into a movie by Matthew McConaughey and Samuel Jackson and Sandra Bullock. And so I like that story. It was about racism in Mississippi and how a little girl got
I think, raped and beaten by some racist people in Mississippi. Anyway, it was a fascinating movie and book, and I liked that one a long time ago. But I don't. It's not like I read one every 6 months or something like that. I would, and it's funny we're doing a podcast. I would listen to a podcast now before I would likely read a book, mostly out of time.
Right.
Now, I may waste time doing other things like watching sports or recreation. So I probably theoretically have the time to read books, but I'm more of a visual learner and I'm more of a listener than really I don't read a ton of books anymore.
Yeah.
So I think maybe school broke me. I was forced to read so many books. So
I was going to say, probably all that law school.
Yeah.
Yeah, I would have to agree with you. John Grisham. I really liked Runaway Jury. Did you see that one?
Yeah. Yeah, I saw the movie and read the book. I went through a spell where I probably read about 10 of his books.
Yeah.
Just because they were pretty easy to read, but also you can tell they were written by a lawyer. Mm-hmm. And that's kind of my beef. Like my wife's a lawyer too. We'll watch shows and some of them are just so obvious that they weren't done by a lawyer. Like we watched Primal Fear the other night along with Richard Gere and Edward Norton. That's a really good movie. But, lawyers nitpick because that's what we do. And you're like, well, that you can't do that. Or that's not the insanity defense.
Right.
Or that, so it's hard to find, like Suits was like great show, but just pure entertainment. There's not a lot of actual law.
Okay.
So I tend to, like when you can tell the shows that really dig deep. Law and Order I actually thought had some, you could tell that you can just tell how involved lawyers are in the making of a show or a movie.
Yeah.
By how accurate it really is. Yeah.
All right, Leland, where can people find you?
So I'm on the web. My website is Leland Lawyer, www.lelandlawyer.com. I don't have the biggest social media presence, but I've got a Facebook page and Instagram that I don't look at too much. But basically I'm on Google is how most people find me, and my cell phone is my cell phone. I don't have other people answering it. I don't have a big staff that people get routed to. So I tend to try to give my clients a little more of a personal experience. But I'm pretty available.
Great. Well, thank you for being here with us today and for educating us on the legal system. I think it's a really important topic. And thank you just for taking the time.
Happy to do it.
Listener, thank you for being here with us. We could not do this without you. If you like what we do here, which is we try to educate you about a variety of topics, please tell your friends about my show. I am on YouTube on that channel. Please subscribe to the channel. It is free, and like the video. I'm also on Instagram, Spotify, and TikTok. Guys, thank you so much for being here with us today. Take care of yourselves. Have a great week, and I will see you soon.